everybody. Welcome to Planet Green Trees.
We have launched.
Thanks for listening. We're here on a special Wednesday night episode. We have launched. Very excited to have everybody here on what we're calling the celebration of America's birthday, July 4th. Isn't that how it goes?
That is how it goes.
A lot of times we lose sight of that. I'm reminded that, is your mic not working? I'm reminded that there's a, I heard this event that there's going to be a bunch of lawyers get together and read the Declaration of Independence on the courthouse steps. I think that took place today or yesterday. I want to give it to my brethren and sisters who are reminding us all of what this country was built upon. Anyways, we're going to talk about medical cannabis tonight. Our show, of course, is called Planet Green Trees. This is officially episode 155. And we have a very exciting show. 155 episodes. As I said, we're calling it the celebration of America's birthday. I'm your host, Michael Komorn, along with me in the studio, Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Everybody's favorite medical marijuana radio producer, Jamie Lowell.
Hello.
Also here from Third Coast Compassion, representing. And, of course, Rick Thompson from the Compassion Chronicles editor-in-chief, and much, much more. Welcome, Rick.
Thank you.
And as we move on into the very important content of the show, and I want to remind everybody that every week we're proud to bring you some of the top cannabis lawyers in the state. And if you have any questions or comments, want to ask some legal issues and bring them to the discussion, please call. Our call number is 1-347-326-9626. You can, our blog talk chat room, I think, is supposed to be open. And if not there, you can try the Michigan Medical Marijuana Association, which I'll return to in a second. But tonight, the spotlight will be on Oaksterdam University's Chancellor Dale Sky Jones from Oakland, California. Oaksterdam, of course, many in our community know, and even beyond our community, has been one of the leading organizations educating people about medical cannabis, how to grow cannabis safely for medical purposes, its different applications, and the various effects that it's had in a historical, educational way throughout the country. I know I spoke at a couple of them as the lawyer, providing information to those interested in medical cannabis. And I know they've just provided a tremendous amount of information to the medical cannabis community. Oakland, California, of course, one could argue has been a microcosm of a community that has embraced medical cannabis and evolved the industry to a point where it has seemingly been interacting regularly with the community in a very positive way. Also, tonight we're going to be discussing, so that's our guest for tonight. I'll be calling in Dale Sky Jones. What time, Jamie?
Around 9.
Very well. Before we get to that, we're going to be discussing recent changes in the administration of the Michigan Medical Marijuana Program, or the administrative rules, or things that are affecting people in their working with the Licensing and Regulatory Affairs Office. Many things are being implemented without the input from the stakeholders, and there was a letter recently signed by a coalition of reform organizers sent to Governor Snyder, Director of LARA, and Steve Arwood, requesting input from the program, allowing for the community to offer its input to the program when, if and any, administrative changes are going to be made. Also excited to announce and bring again to the community last week's guest, Curtis Kile, who is this very, very courageous man who's been driving in his wheelchair from Taylor, Michigan, all the way to Washington, D.C., in a tribute to his father and also to promote cannabis legalization. He'll be calling back in to give us an update on how things have been going and his ultimate destination of Washington, D.C. I think he's supposed to arrive Thursday, and hopefully to talk with...
He may be there today, so hopefully he'll be calling in from his destination. We'll have to check that out.
Mm-hmm.
I also wanted to comment that there was some fantastic press about this. I know, Rick, Rick and Jamie were pivotal in making this happen. Our Detroit Free Press had run an article on his story. It was a very inspirational one about the necessity for cannabis reform and the need for the medical cannabis laws to be honored by the federal government, and it got a lot of attention. And I know that the Planet Green Trees episode 154 was mentioned, the Detroit Free Press. So we're very proud of that. Anyways, also adding to the entertainment tonight, we'll have a court report from Steve Green from the Human Solutions and his review of the screening of the American Drug War 2, Cannabis Destiny, a film by Kevin Booth. Also, I'm going to do a rant in a little while. I want to thank all the contributions for tonight's show by Rick Thompson, Jamie Lowell, and, of course, Chad. Tonight's sponsors are Komorn Law, 1-800-656-3557. The Michigan Medical Marijuana Association. I want to thank all the moderators and administrators who volunteer their time to make the forums at that website a safe, comfortable place to evolve the conversation about medical cannabis. Also, give a shout-out to Kevin Spidler, the Med Joint Community Center in Ostamo, Michigan. Also, he's the director of the NoHio Ballot Initiative. Maybe one day we'll get a call from him on events, how things have progressed. Also, I want to give a shout-out to our good friend at the Marijuana Ranch. Always events happening regarding cannabis community and cultural center for learning about cannabis. The Ranch, 313-422-5281. We always want to give a shout-out to our good friend, the Rancher in Detroit. So, as always, much to talk about. It's been a little bit of a short week. We've been discussing at some length the history of the Michigan Medical Marijuana Act. 3 of the last 4 episodes designated a period of time to reflecting on some of the changes, both from perception and implementation of what we were calling the Renaissance era to the what could be called the Dark Ages, when the raids began to happen, and how things got unfortunately set back. And then, of course, how the Act itself has been interpreted in its implementation via the courts. And we went over that some last week, and I discussed a little bit about Section 8 and how it's all been played out in terms of the specific implementation, how the courts and what we know, what we can say about the law, and get some clarity on what one would need to do in order to try to be in compliance with the overall idea that even after all it's been through, whatever failures in its implementation, people should not be discouraged from participating. And that a lesson that I think we could say for this point, the era that we're in right now, I don't even want to call it the modern era. I think there are some, settled guidelines on how people can participate and can be encouraged, and encourage others to participate, and have little, if any, fear on legal ramifications that we've heard the horror stories about in some of the failures. But one of the things that does come to mind and is a topic that we're going to discuss, and I briefly want to address, is the issues of some of the rules changes that have taken place. And what I'm talking about are not legal rules in terms of the Supreme Court or Court of Appeals or even the legislature. We've discussed some of those things, but the administrative rules. The administrative rules were developed and promulgated by the the Michigan Department of Community Health, which is now a defunct agency that has been taken over by the License and Regulatory Affairs. But that at the point in time where they were developing the administrative rules, they specifically requested input from the medical cannabis community and stakeholders and patients and lawyers, and they did participate. And one could say that as far as the law went and the way the administrative rules were set out, there was a lot of input from the community itself. And there's stories and recorded events which probably could have been talked about in the pre-Renaissance era. But as we find now in this modern era, which is kind of reflective of our Attorney General and the way that he has taken over and involved himself with much of the administration of the agency, we find that there's been some changes to the administrative documents and other rules regarding the way in which LARA is interacting with those persons that want to become registered patients or registered caregivers. First, what comes to mind is the change of some of the forms. If you notice, anyone that has addressed or looked at the forms, they have now divided up what was originally in one portion of the form all of the medical conditions, identifiable diagnoses, as well as the other conditions or symptoms. Those were always included within a specific portion of the patient application, which made it easy for the physician to either check off one of the diagnoses, specific diagnosis, or identifying one of the conditions such as chronic pain or nausea or loss of appetite or muscle spasms. Now, those other conditions are in a separate area, making it more confusing, one might say, or at least creating more ways in which the department, as I've understood, has taken issue with the proper way in which the application has been filled out. And any time you have rules like this promulgated that are changes to the way things have been done, there's always going to be a certain segment of error or trial by error that needs to be gone through. And traditionally, the department has not been very effective in being able to verbally get back to people. They've always been backed up. Getting the cards out on time was always a challenge for them, and now that they have been a little bit more effective, and I understand it's about 6 weeks now, regularity, not the 21 days that the law would require, they're still not effective about getting back to people that find themselves in these positions of being rejected on a form because the form wasn't proper, getting back to the doctor, and what happens in the interim. And we know from all too many stories that these were those people caught in that limbo, waiting responses from LARA, needing the doctor to complete a certain aspect of the form to properly fill out the form so it'll be accepted and a card will be sent out, and people get arrested during this period of time, causing more problems. So critical to this is that people become more familiar with and make sure that the doctors are addressing both portions and are more descriptive and more definitive about why they are creating the certification. But it goes beyond that, and an important point probably to talk about here is that in addition to any familiarity that people have about what's supposed to take place when the documents are being filled out, much more should be taking place with their interactions with the physician. And just to briefly talk about for a second in this point of history of what patients should expect and the challenges that they have, not to be discouraged, is that they should begin to expect more responsibility over their medical chart and begin to expect the physicians that are doing the certification to, most importantly, be taking a medical history, discussing medical treatments historically, how other medications have been affecting them, what, if any, effect medical cannabis has had on their debilitating condition, and genuinely believe that they're going to follow up with the doctor moving forward. Another aspect that many people don't realize, which I think has become very traumatic, and we've found about this in cases that I'm involved with caregivers, when a caregiver is charged with a crime, even though they're presumed innocent, their criminal record will reflect that an arrest and charges have been brought. This criminal record, in the lien system, or what reflects whether or not they have pending charges or any prior charges, is the database that's accessible to the law enforcement community and the prosecutor's offices, and it is the same database by which LARA is utilizing to determine whether or not an individual has a felony conviction that would make them ineligible to become a registered caregiver for a patient. And what you're finding is people are acting as a registered caregiver for a patient if they get charged with an offense, presumed innocent until proven guilty beyond a reasonable doubt. And along the way, what is obviously apparent is, despite the fact that they may be arrestable under Section 4, they clearly have a defense under, well, most of them have a defense under Section 8. But that's a piece of the puzzle that is probably going to be litigated or will bring about results that may be different than the traditional felony convictions that take place when a person's charged with a felony. What I'm suggesting, or what I'm telling the audience, is one of the problems that's occurred with LARA is that they are, for caregivers that are looking to renew their license for their patients who have pending criminal charges, not a conviction, but a pending criminal charge, they are time and time again being denied their caregiver license. They're being denied the registration connection to the patient and the immunity that goes along with it for growing plants on the patient's behalf and or transferring cannabis to the patient for the medical purposes. The cards are being denied. I have a case that is, a very important case to me because it reflected the power of the Section 8 defense. In Genesee County, the case that I wrote about is the 14-pound case, where the judge in Flint, who had never heard about or knew about and had very little knowledge about medical cannabis, at one point said, well, that tells you what I know about marijuana. I always believed that the leaves were the thing of value. If I got dropped in a field of marijuana, I would have been the guy running out of there with a bunch of leaves. I had no idea that it wasn't the leaves and that that's the part that's discarded. He also, my favorite quote, I think, in any of these hearings that we've had, after listening to the patient testify about her medical condition, she got down off the witness stand, turned over and said, "Ma'am, you are a beautiful person, and I pray for you and your family." Meaning she had gotten to him and emoted sympathy or compassion because of the story that she told and how cannabis had helped her, as we've heard so many times throughout the community. The point is that after the case was dismissed under Section 8, and during this period of time, he had renewed his caregiver license to be a registered caregiver for that exact patient. And you know what happened? LARA denied him, sent a letter to this patient saying he, Komorn's client, cannot be a caregiver because of this pending felony charge. Well, at this point in time, we'd had a dismissal on the record. We'd had an order of dismissal signed by the judge showing that all those charges had been dismissed. The forfeiture case had been disposed of because of the dismissal under Section 8, which is a tool to use if you do get a dismissal under Section 8 to get all that property they stole from you back. But even getting the document, a signed order to the LARA, did not result in any quick action. If you ask the question, how interested are you, LARA, to facilitating Komorn's clients' caregiver rights back, they'd say not much. And we don't even have a vehicle, nor do we have a department or compartment that's working on that right now. So we'll just put that in the pile with all the other stuff. So let me tell you, this is a real problem with the way the administration has dealt with it, and it just begs of many, many issues and problems that we could go on a lot about. I mean, the first one that comes to mind is that presumed innocent. How can you deprive someone of licensing when the requirements are that they not have any felony conviction? How you can suggest that a pending felony case is going to be a basis to deny them of it? Well, they might argue it's a license. It's a permit. It's not a right. So in order for you to comply and get your license, you've got to follow certain rules. So an example that comes to mind is the privilege to have a driver's license. This is not a right. People get a privilege, a license to drive a vehicle. What are the rules that go along with it to maintain it? You can't have too many points on your record. You can't have too many drunk drivings. You can lose it for other types of crimes that you commit. You have to provide a license and an insurance of your vehicle and registration of your vehicle to have that. If you don't have it, you're going to be ticketed and you might lose your license. So there's certain concepts that we understand in the law about maintaining a license and the requirements that go along with it. But those for this particular license require that you not have any felony convictions within 10 years or any felony drug convictions of the previous laws. But either way, if you have a felony conviction, we're talking about an allegation or a charge. The response might be, well, let's look at license to carry pistol permit, or what was formerly known as carrying a concealed weapon permit. This is a license or a permit that is not given to anyone. In order to obtain this license or permit, you have to go to a school and take a class and become educated. You have to pass a test. Your background check has to reflect that you have no prior felonies or misdemeanors. And you know what, Komorn, when you argue about that stuff, the pistol permit licensing board, which is in every single county, the members being the sheriff's department, the prosecutor's office, and usually someone from the community, that make the policies of what is going to be the rules of getting a pistol permit, also make the rules of taking away the pistol permits. And the rules are consistently across the state that if, while having a license to carry a pistol, you pick up a crime, they're going to suspend your license pending the outcome of the case. They do that because they don't revoke it, they suspend it, which is distinguishable, I would argue. Also, if you win the case and you bring back the dismissal, they will lift the suspension and give you a full-fledged license back. Further, in order to get your license as a carrying a concealed weapon or pistol permit, you have to have no criminal record at all. And it would make sense then that if you get any kind of criminal charge, a misdemeanor, any misdemeanor would result in you losing your pistol permit. And it would also be a reason why you wouldn't be granted one in the first place. So what I'm saying is that the threshold of getting a pistol permit is much lower. Meaning if you have a misdemeanor, you're not going to get a pistol permit. But you can have a misdemeanor and still become a registered medical marijuana caregiver. And furthermore, what we know is that in addition to the charges that may have been brought based upon an arrestable offense, that someone had unusable material that is not defined and seems to be too much, and an individual gets arrested because they have more than 2.5 ounces, but they come to court in their Section 8 and get it dismissed, or because of medical reasons, the prosecutor might reduce the charges and offer some kind of resolution or disposition of the case that would not result in the caregiver license being not allowed. I'm suggesting that this policy by LARA at this time is so outrageous, and it does warrant some legal action. I know I've talked with other lawyers about pursuing this, but I bring this to everyone's attention because this is a classic example of how things are now in the modern era that were different than the Renaissance era. This is a classic example of the LARA acting on their own in what can only be described as a violation of an individual's right to be presumed innocent when charged with a crime. And the conclusions that are being drawn in these cases where caregivers are being cut off from their ability to grow for their patients is just absolutely unfair and is everything what's wrong with LARA right now, and a classic example of how they really should have and must take input from the medical cannabis community so they understand the difficulties at times of developing those quality relationships with the caregiver and the caregiver's rights or the patient's rights to obtain medicine from the caregiver being cutting off, creating more challenges. So it's a very important legal dilemma that I think is existing. I want to hear from any caregivers who've run into this. I know of many with cases that I have pending, and I also want to hear if anyone's heard anything about any of the other regulations that have been that they've been affected by. And in closing the rant, before we go to a break, I want to talk just briefly about what could be described as the most recent Supreme Court issue that was addressed regarding medical cannabis. It's the case of People versus Green and its impact overall on the legal landscape of medical marijuana as it relates to the types of transfers that can take place. What is People versus Green? Many of you will recall People versus Green was a case that dealt with the patient-to-patient transfers where there was no money exchanged. And at the time of People versus Green going through the trial court and the Court of Appeals, the controlling case was the Court of Appeals case of People versus McQueen. And one of the things that People versus McQueen, the Court of Appeals had identified was 4 different types of transfers, and but focused primarily in its opinion of money being exchanged as a exclusion to the principle of medical use, and that when you bring medical use into a patient-to-patient transfer, that it does not recognize or contemplate money being exchanged. And that's the way McQueen was. We know, however, that the Supreme Court later ruled in McQueen that money and the exchange of money has nothing to do with it, and that you can sell marijuana. The sale of marijuana has absolutely nothing to do with the legality of the transfer of marijuana, whether there's money involved, whether it's overpriced, underpriced, a donation, whatever. It doesn't matter. What matters is who the transferor is as it relates to the patient. We know from McQueen that the patient can acquire from anybody, and they're protected. However, what we also know is that the transferor, if they're not directly connected to the patient, they're not one of their 5, they are subject to arrest, but can defend themselves under Section 8 if they can establish Section 8 defense, and primarily that the marijuana that was transferred was for that specific 6th patient or patient that they're not directly connected to's medical use and not some other reason. What was interesting about Green was that it came out about 1 week before McQueen, and it ruled essentially that in light of the Court of Appeals opinion of McQueen, which addressed money as being the critical factor of the exchanges being lawful, Green took the separate type of transfer that we're talking about, not patient to patient where money's involved, but patient to patient where no money's involved, and said that that is a transaction that is protected under Section 4. That the patient to patient transfer where no money is transferred between those two individuals is a protected transfer under Section 4, and that those individuals are not subject to arrest, prosecution, or any penalty. I say that I don't want this to be misinterpreted. That was the ruling in Green. That ruling in Green was based upon the McQueen Court of Appeals opinion, which was still focused on money, and I just told you that that doesn't matter anymore. The chronology of Green was that it came out 1 week before, and Green was a Court of Appeals opinion. Court of Appeals said patient-to-patient transfers of people versus Green are protected under Section 4, and those individuals are not subject to arrest, prosecution, or any penalty, and we're relying on the McQueen Court of Appeals opinion. And specifically, that's their ruling. What happened was McQueen came out 1 week later and turned all that principle and the logic that was used in People versus Green based upon the money transactions and the way that the law had been analyzed in the Court of Appeals on its head and threw out the concept of the money being transferred. So the question was, when Green had found that patient-to-patient transfers are lawful under Section 4, and 1 week later the logic, reasoning, and analysis that was used to make those conclusions in the Court of Appeals had been rebunked or refuted and completely overturned when McQueen was ruled upon unanimously by the Michigan Supreme Court, what impact did it have on Green? An interesting anecdote to this was that the Attorney General that was involved in that case, 1 week immediately after McQueen came down, filed a motion for reconsideration in the Court of Appeals, asking the Court of Appeals to vacate their ruling that patient-to-patient transfers where no money was exchanged was lawful, based upon the recent Michigan Supreme Court decision. And the Court of Appeals said, no, Attorney General, we're not going to, which is interesting. But has no real impact because recently, as of June 19, 2013, the case of People versus Green was addressed by the Michigan Supreme Court. And what they said was that in Michigan versus McQueen, Supreme Court held that under the MMA Section 4 does not extend to registered qualified patients who transfer marijuana to another registered qualifying patient for the transferee's use because the transfer is not engaged in conduct related to marijuana for the purpose of relieving the transfer's own medical conditions, suggesting that clearly we're reaffirming the principles outlined in the McQueen decision and remanding the case to properly deal with those issues consistent with the Michigan Supreme Court's opinion in People versus McQueen. What does all this mean? It means that the patient-to-patient transfers allowable under Section 4, highlighted in the People versus Green Court of Appeals decision, has been overruled by the Michigan Supreme Court and remanded in order to be entered consistent with the McQueen decision, which says the following as it relates to transfers: that the only caregivers that are protected, or any individuals that are protected from arrest, prosecution, or any penalty from the sale, transfer of marijuana, are those registered caregivers that are connected to the registered patient through the registry, no more than 5. And those are the only and exclusive transfers that are protected. However, if you transfer to 6 patients, you still have your Section 8 defense. That's what all this means. That's the rant. Covered a lot of material. Got a great show, a lot to talk about, exciting things, and a lot of information for our community. With that being said, you are listening to Planet Green Trees. Call numbers 1-347-326-9626. And we're going to be right back.